All rise.
Mr. Johnson.
Before I continue with several more points in relation to this issue, I wonder if I could just deal with a short point about which Lord Walker asked, which was in relation to the mention of some pension trustees in the subscribers' agreement. I understand, thanks to those instructing my learned friend, that these are trustees of a pension scheme into which one of the shareholders transferred his shares. That was a Mr. Cook, and it's understood that he was a trustee and that there was probably also a professional trustee, and those would be the trustees of the scheme. That's as much as I've been able to discover, and I hope that meets the point that my Lord was asking about.
And they were, it seems, no longer shareholders at the time of the sale.
That seems to be so, yes.
Thank you.
Yes. So, my Lords, moving back to the series of points which I wish to make in order to, I hope, demonstrate that each chapter ought to be approached on its own merits. I have, I think, 8 points. I've made the first one before lunch, and that was the one about undervalue. The second one is a short one, which I think I've already dealt with, but if I can simply insert it for completeness. And it's this, that as my Lords have seen, several of the chapters are concerned with charging tax on acquisition of employment rights, employment-related securities, or in respect of conditions or arrangements attaching to acquisition. And those broadly have the effect of reducing what comes into the charge to tax at that time. So, for example, we've seen Chapter 2 on restricted securities, 3 on convertible securities, and 3C on those acquired at less than market value. By contrast, Chapter 3D is concerned with taxation on disposal. And in my submission, one can make 2 general points about that. Firstly, that one can't, as a matter of principle, assume that precisely the same considerations will apply on disposal as on acquisition. And secondly, and this is a point we've touched on before, that, as I would submit, there is no general principle that you get taxed at the beginning rather than the end, because as we've seen in Chapter 3D, that's simply not so. Point 3 is simply to note that the legislative history of the various chapters is diverse. And as my Lords have already heard, so far as Chapter 3D is concerned, its primary purpose was to address the so-called stop-loss situation. And it was, as I understand it, conceived as an anti-avoidance measure to deal with that. I think it's fair to say, having regard to the Appellants case, that that much is common ground between the parties. The reference to their case is at 471. By contrast, if one takes, for example, Chapter 3C, it was directed at the situation where part of the purchase price of shares on issue was left unpaid. Or I should say all or part of it. So either the employee didn't pay for them at all, or part of it was left unpaid, or indeed, as we can see from section 446Q, it covers also the question of partly paid up shares. And perhaps just give the reference to that. It's 446Q subsection 3.
Yes.
And as my Lord saw yesterday, the way in which that chapter works, which I'm coming on to in a moment, is to suppose that a notional loan took place. And that one would assume that that's because a failure to pay a purchase price would not naturally be regarded as a loan, so the chapter deems there to have been a notional loan of the unpaid price. But one can see that the situation at which it's addressed is actually, it's quite a different situation from that covered by stop loss. And so although superficially it may seem that one chapter is the mirror image of the other, the reality is they're actually seeking to do quite different things.
Subsection 3 is quite interesting because it's directing attention to what is to be taken to be the market value in that situation. As I read it, the reference to market value is to be what it would be if the securities were fully paid up.
Yes.
And that's consistent, I think, with your primary argument as to how you approach market value. But it reminds me that one of Mr. Sherry's points was to direct attention to the way market value is dealt with in section 437.
Yes.
At page 8192. Are you coming to that in one of your other points, or is this convenient to let us look at it? Because that's
yes, I think I am, my lord, yes. I'm happy to deal with it whenever it would be convenient to the court.
I don't want to take you out of order. It's just an example there where he says, well, the market value direction there assumes that you could determine that they were convertible or whatever.
Yes.
And these refer to things that are not part of the, as it were, the class rights.
Yes. I think, as I understand his point, it seems to be to the effect that that provision would be redundant if the approach which I've put forward were
Yes.
correct.
Yes.
And I think all I would say about that is that, as my lords know, and as indeed Lord Hoffman has said in, I think, more than one case, the argument from redundancy has to be approached with some circumspection, in the sense that, not least in complex provisions like this, one might not be surprised if the draftsman were to spell out everything rather than at the risk of some redundancy. And that one can't necessarily infer that the situation would be different otherwise. I'm not sure if this is of assistance, but the more general point that I wanted to make in relation to that section and its predecessor is this, that as we can see in section 436, securities are convertible securities, it's said, if A, they confer on the holder an immediate or conditional entitlement to convert, and then B, a contract, agreement, arrangement or condition authorises or requires the grant of such an entitlement, and then there's further reference to contract, agreement and so forth.
Yes.
Now, some weight, as my lord has said, is placed on that provision by the appellants, but in my submission, what it really shows is that for Chapter 3 purposes, this spells out in terms that the right to convert may be conferred either by the securities or by some other agreement. So either of those things will do. But when we seek to say, well, what does that tell us about Chapter 3D? The answer I would give is Chapter 3D simply does not address that point. And so it's left to this court to determine, by reference to the language and purpose of Chapter 3D, whether or not collateral agreements ought to be taken into account. So my broad submission is that it becomes crystal clear because of Section 436 that it doesn't matter whether the rights are conferred by the security or by some other contract, but that doesn't tell us where another chapter in this part is silent about where the right may be contained, whether it's included or not.
I vaguely wondered, I'm not saying it's right, but I wondered whether the fact that it's spelt out in B and C suggested that if it weren't for that, if it weren't spelt out, you wouldn't be able to imply that something which was in a contract and so on made the share a convertible one.
Yes. I take my lord's point. I think that must be. I think that must be a possible view, that it is made express precisely in order to avoid the sort of argument that we're having about Chapter 3D. While I think I would be inclined to agree with that, the general point I would make is that it's quite helpful when one's considering the overall coherence of the chapter to note that for Chapter 3C, as my Lord Roger points out, we know very clearly which rights are in issue, whether they come under the securities or under a separate contract. By contrast, nothing is said about that in Chapter 3D. I would not invite the court to treat that as some inference that the position is necessarily different, but rather to treat it as a reason why one has to understand the purpose of Chapter 3D to decide whether such agreements come in or not. And for the reasons I've mentioned earlier, my submission is because Chapter 3D cannot work if one takes these agreements into account, the natural inference is when regardless has its purpose that they don't come into the valuation exercise.
Yes?
I think, my Lord, that was probably slightly lost track of numbers, possibly my fourth point. But
Sorry, it's my fault.
at any rate, the number is not very important, other than to reassure my Lords that I'm not going to talk for very long. The next point I wish to make is that if one has a regard to the legislative language and techniques throughout Part 7, again, it's my submission that we see a variety of different techniques which suggest that there is no single approach that one can divine, which will therefore give one the answer to the question whether rights come in under Chapter 3D. And by way of example, as I've just mentioned, the Chapter 3C works by reference to the notional loan. That has no part to play in Chapter 3D or elsewhere. Chapters 3A and 3B, to give another example, are concerned with securities with market values that are either artificially depressed or artificially enhanced. And their concern, as they spell out, is to assess market value as if things done other than for genuine commercial purposes had not been done at all.
Could you possibly give us a very simple example of 3B working? The sort of arrangement which is in mind there?
The chapter is concerned with artificially enhanced market value. I think, my Lord, I wonder it might be simplest if I were to take advice from those instructing me on what would be the clear paradigm example of the 3B case. The point that I've been seeking to make was simply, for example, if I take, my Lord, to 446L, subsection 6, the market value is the amount that would be the market value of the securities on the valuation date if any non-commercial increases during the relevant period were disregarded. So I think one can see that what it's seeking to get at is to say that, and again, this will be an anti-avoidance provision, it's seeking to identify the genuine transactions that actually affect the market value.
I just don't see how one could save tax by artificially increasing the value of shares, but no doubt there is an answer.
My Lord?
Well,
Because Chapter 2 relies on the value of restrictions, which depress value, you can artificially get out of those charges by increasing the value, is one example.
You would, if it wasn't for this charge.
Indeed, my Lord.
I mean, that's,
Yeah.
you know.
Things of that sort.
Yes, I'm grateful to my friend, and that is accepted on this side of the bar also as being a relevant example. So that it ties in, as my learned friend says, to the restriction point. The next point I wanted to make is that, again, looking for the presence or absence of common ground, is that there are fundamental differences in the nature of the tax charge as between the various chapters. So that as we've seen, the Chapter 2 tax charge, which is in section 428, is levied by reference to the proportion of the unrestricted market value which was not paid for at the outset. And I think my Lord saw that that was summarised in the Respondents' case in paragraph 30. And I recall that my Lord in the chair took my learned friend to paragraph 30 of the Respondents' case and asked whether that was broadly accepted as describing how that chapter works, and it appears that broadly it was accepted.
Yes. So 4282 is identifying how you approach UMV at that point.
Yes.
The chargeable event is described in 427.
My Lord, yes. That's right. But really the point I make, which indeed my learned friend took my Lords to this yesterday, is that the amount of the charge is set out in section 428, and it's related, as he said at the time, the equation is somewhat more complicated than is necessary where there's only been a single chargeable event, and it seeks to take account of cases where there's been a series of chargeable events. But the only general point I seek to make is that, which I think is common ground, is that the charge is actually based on a proportion of the increase in value, as it were, as opposed to the whole. And what I wish to do is to contrast that with Chapter 5, which is to do with options. Because there, under section 479, the charge to tax is on the whole amount of the gain. So really the short point is that the nature of the tax charge is not uniform across Part 7 either. So I think the last 2 points are ones that are addressed in the parties' respective cases, and they relate to Chapter 2 on the one hand and Chapter 3 on the other. In relation to Chapter 2, the material in the Respondents' case is Chapters 30 and 31, paragraphs 30 and 31. And as is explained there, the Chapter 2 is concerned with restricted securities, that is, securities worth less than they would be but for the restriction. Tax is charged on them when the restriction is released. And because the purpose of the valuation exercise under Chapter 2 is to apply tax to the value arising on release of the restriction, because of that, valuation necessarily takes into account personal restrictions applying to the securities.
Could you repeat that? I'm sorry. You apply the tax to the value arising on the release of the restriction.
Yes, my Lord.
Go on.
And because of that, the valuation exercise necessarily takes into account personal restrictions that apply to the securities.
Yes.
And the reason is that only in that way is it possible to measure the value that arises when the restriction is released. But in my submission, that conclusion rests on understanding the purpose of the Chapter 2 provisions, rather than trying to divine it from a comparison with other chapters in Part 7. So that in my submission, again, it supports my overall proposition that the purpose each chapter is designed to serve necessarily affects the appropriate approach to market value. Well, before I leave that example, I should perhaps comment on two paragraphs of the Appellant's case that touch on this matter. And they are on page 22, paragraphs 10.2 and 11.2. And if I've understood them correctly, they really make the same point. The first in general terms and the second in terms more specific to the present facts. But I think it's, so far as one can see, the proposition being put in both of those paragraphs is that where you have restrictions on shares, Chapter 2 is clearly in point. And then it's said that assuming that unrestricted market value was paid on the issue of the shares, there would be no further charge under Chapter 2. Now that's obviously right. If the full market value has been paid at the outset, Chapter 2 doesn't come in beyond that. And then it's suggested that it's very odd if, nonetheless, there could be a charge to tax on sale proceeds which exceeded the market value of the shares. And I think, as I said earlier, I think it's really the same point that's being made hypothetically in paragraph 11.2. It's hypothetical because we know, because of the date of the share issue, that Chapter 2 actually did not apply in this case. But the point again being made, which I believe to be the same point, is that if full value is being paid and Chapter 2 is therefore exhausted, there's no reason why Chapter 3D should apply later. Well, what I have to say about that is firstly that this is all hypothetical. Secondly, I accept that if full value was paid, then no Chapter 2 charges would be possible later. But in my submission, that does not support the proposition that by paying an amount at the outset, that should protect an employee from ever having to pay tax in relation to a potentially substantial gain when he subsequently sold or disposed of his shares for more than market value. Because what really the 3D charge is capturing the difference on disposal between market value and the actual consideration. And in my submission, there's no reason why one should assume that the 3D charge could not, on appropriate facts, arise, simply because the Chapter 2 charge in relation to release of restrictions would not itself arise on those facts.
I think it's accepted the language of 3D is so wide that unless you draw something out of the previous provisions to put it in the context, your proposition would be right. But the argument, of course, is that the context tells you differently.
Yes. Lord, I'm not sure I can say very much to that other than to emphasize that what is significant in my submission is, firstly, that the wording of Chapter 3D says nothing about how one should treat personal agreements, so that, secondly, the answer how one should treat them must be derived from considering whether the chapter will fulfill its purpose if rights are taken into account or if they're left out of account. And for the reasons I've already mentioned in my submission, it's only if they're left out of account that the Chapter 3D anti-avoidance provision, as I said, can achieve its aim. And go on from there to look for a moment at Chapter 3 about convertible securities. And this again is covered in the written case at paragraph 32. But as is set out there, and as I think I can perhaps say more concisely now, the the purpose in my submission of Chapter 3 is to identify the value of the conversion right. And in order to do that, the chapter requires that the amount deducted from what is actually realised on the occurrence of a chargeable event is the market value of the security, leaving aside the right to convert. Only if you approach matters in that way can you identify the value of the conversion right itself. So that again, when one simply considers what is the purpose for this particular treatment in this particular case, the purpose in my submission is in order to identify the value of the conversion right. And that is what dictates the particular treatment of personal rights in relation to that chapter. And here too, I think, my lords, I should comment on one paragraph in the appellant's case. This is paragraph 10.1. And as my lords will see, in the first 6 or 7 lines, that it's set out that if full consideration is given at the outset by an employee for shares plus conversion rights, then on any sale there will be a charge to income tax under Chapter 3, but only on the amount by which the consideration received would be less but for the conversion rights, and that would in turn be reduced by the amount effectively given for the conversion rights at the outset. Then it said if the revenue are correct, however, in relation to Chapter 3D, there is no reason why they should not seek to bypass this limitation and raise a charge under Chapter 3D on the difference between the consideration paid and the value absent the conversion rights without giving any credit for the amount paid for the rights at the outset, and so forth. My lords, what I have to say to that is that the hypothesis being put forward here is we have convertible securities and we have a single disposal which comes squarely within Chapter 3. And that's to say there's a chargeable event under Chapter 3.
Section 439. Is that right?
My lord, yes.
Yes. Conversion, disposal, release, or whatever.
Yes. My lord, yes, that's right. And really, the short point I make is that if one has a disposal that falls squarely within Chapter 3C, then that is the basis, Chapter 3,
yeah. Then
that is the basis on which it should fall into the charge to tax. And contrary to what the appellants say, there is in fact a reason why the revenue should not seek to bypass that limitation, namely that they should not seek to tax the same amount in 2 different ways. And so, while one might invent situations in which there appears to be potential difficulty in the construction that I've advanced on behalf of the revenue, if one takes into account the reality that the revenue will apply the charge to tax according to the chapter under which it naturally belongs, and will not seek to charge tax under multiple chapters, then in my submission the point made in that paragraph is not substantial. So, my lord, summarising what I have to say on this second chapter of the argument, my submission is that one doesn't really need to get into the detail in the way that my learned friend did about how these chapters work. The reality is, if one has regard to Part 7 as a whole and looks to see the different language and the different purposes that each of those chapters seeks to serve, then there is no reason to infer from a provision in one chapter any particular conclusion about the workings of another. I don't say that there's no interrelationship, but what I do say is that looked at overall, there are not sufficient generally applicable features in these various chapters to assist in determining the nature of the asset to be valued under Chapter 3D. Rather, that exercise depends on construing the sections in Chapter 3D by reference to their language and their purpose. My Lords, in relation then to the third argument, which is the one where my learned friend seeks permission to introduce this in this court for the first time, I think there's very little I can add to what is said in the written case for the respondents in paragraphs 36 and 37. If I could simply make the points quite shortly, the essence of it is that the question for determination by the commissioners and then later considered by the Court of Session was the value of these shares as employment-related securities. The issue has never been focused in the way that my learned friend now seeks to focus it. I think he seeks to draw some support for this approach from a comment made by Lord Mackay of Drummadoon in his opinion. But in my submission, that's to place far too much weight on those observations, which are in, I think, paragraph 90 of his Lordship's opinion. I think it's quite clear from having been there myself that the Court was not at all addressing the matter on the basis that rights fell to be considered separately from rights under the agreement fell to be considered separately from the shares and that they might require to have a different taxation treatment. All his Lordship was saying, I think, is that he was satisfied that these rights did not properly fall to be taken into account when valuing the shares.
He says it was a debt that fell due in terms of the subscription agreement rather than one arising out of rights attached to the shares.
Yes.
Yes.
No, yes, that is as far as it goes, but in my submission it doesn't go very far, and it's certainly not a matter that was in any sense raised before the Court. I think the only other point that may be worth mentioning that isn't already in the written case is my learned friend has raised the case in tab 5, a Brady case before my Lords this morning.
Yeah.
And there's a quotation from that in his written note of argument. My submission is that if one simply takes this is on page 11 of his written note, the second bullet point under paragraph 3,
Yeah.
where he quotes from Lord Oliver, who says, or who allows the late matter to be introduced on the basis that there is in fact a conclusive answer in law to the contention. And as was explained, the contention was that an agreement was illegal because it was, if I recall, unlawful financial assistance to a company. And a straightforward statutory point about that had not been taken before. In my submission, when we're dealing with matters of this complexity, it would be quite difficult to say that what my learned friend seeks to do now is to introduce a point that is a conclusive answer in law to the various contentions in the case. So it would be my submission that he cannot derive any support from that.
What do you have to say about facts not found? Because I think Mr. Sherry's point was you really don't need any more facts. You've got all the information you need to draw the conclusion which he wants, and that you rather overstate the position in paragraph 37 when you say that that since no consideration was given to this by the Special Commissioners, we don't have the facts.
Yes. Lord, what I would say to that is that as we've been discussing in relation to the primary argument, that's to say whether the personal rights come into the valuation of the shares, one can see that the discussion that we've had over the last 2 days about that point involves some detailed scrutiny of the particular rights and obligations under the subscriber's agreement. Now, as far as I can tell from what the Special Commissioner has written, he was not seeking to approach the matter because it wasn't approached in that way before him, in the sense of trying to identify which rights might carry and which rights might not. And he, therefore, I would suggest, has not set out any basis on which he could apply a proper valuation. So I think that's all I can say, that as is set out in the written case, that the appellants would seek simply to infer from the findings in law by the Court of Session that the result about the valuation of the agreement, the rights under the agreement, follows as a matter of course. I would simply say that there isn't any reason to assume that the two things, when separated, have to be treated purely by applying that kind of formal logic. It would be a matter for evidence.
So it's the fact that on this assumption you have to approach the rights under the agreement separately from the shares that you say raises the question as to whether the simplistic approach, that it simply makes up all the difference between the market value and the consideration, is right.
Yes, yes.
I thought Mr. Shea's position was, well, if so be it, but all we're concerned with is the principle of the matter, and if it had to go back for determination on the fact, then so be it. I mean, I thought that was the way he put it.
Certainly an alternative, yes.
Yeah. That may be, I think, how it was approached, as possibly not as a primary motion. I think the only other thing I can usefully say is that it's my submission that if my lords were to be minded to explore this route further, contrary to what I've said, that the way in which the appellants have sought to characterise the issue is actually not correct. They characterise the rights under the agreement as an interest in the proceeds of the other members' shares. The way I would characterise it is that Mr. Gibson simply had a right to require them to procure that the company or the purchaser paid him more for his shares. So that his shares are what he's interested in, his shares are what he sold. And he did not dispose of any interest in the proceeds of sale of his fellow members' shares.
Yeah.
So, for those reasons, I would invite your lordships to refuse to take account of this third point, but in any event, if willing to do so, to reject it on the basis that the argument about the interest in other members' shares is not an accurate characterisation of the rights actually conferred by the agreement. Lord, so those are my submissions on behalf of the respondents.
Thank you very much indeed. Mr. Artis, do you want to add anything?
There's nothing I have to add, my lords.
Thank you very much. Mr. Shelley.
My lord, it's only It's only when we put all the pieces back together that we can understand market value in Part 7. So my learned friend's thrust has been, well, all you need to concern yourselves about is Chapter 3D, and different problems and different solutions might apply elsewhere. But what I would invite your lordships to hang on to is the provision in section 421, which requires market value based on the capital gains tax rules to be applied across Part 7. And in each of the provisions we looked at, including D, we get a cross-reference back again. And my learned friend says there is limited interaction between all these provisions, and in particular, limited interaction between the provisions I've explained in 3D. But on the very issue we're talking about, the theme runs all the way through. It's the same thing. It's market value. The draftsman has gone to great lengths, repeating it in each chapter. We're talking about the same thing. Whilst it is true that the history of the various predecessors to what's in chapters 1 to 5 was different, nevertheless, as your lordships have seen, this version was enacted as a piece in 2003 in the Finance Act in Schedule 22. It was all drafted by the same draftsman. So whilst some of the purposes for the different bits have different histories, and it shouldn't be forgotten that whilst Chapter 2 talks about restricted securities and Chapter 3 talks about convertible securities, there were earlier but very different provisions about conditional securities and convertible securities. So those provisions didn't come out of a vacuum in 2003. What the Revenue were doing, what Parliament was doing when it enacted Schedule 22, the 2003 Finance Act, was introducing some kind of rationalisation and code, and although provisions had a history that one could see, they weren't necessarily the same. Chapter 3D, the stop loss provision, was probably the least changed from before. Now, another general comment which bears on everything my learned friend has said. Not all share incentives result in taxation, share incentive gains result in taxation of the gain as income. So just to take the very simple example, which I think my Lord Brown perhaps was getting at, if my employer gives me a share today, I pay income tax on the value of the share if it's a gift. But thereafter, if it goes up, I pay capital gains tax. And if I buy a share today and I pay the full value, then absent any strange and particular statutory provisions, I would not expect to pay any more income tax on that, even if the opportunity to buy the share was given to me by my employer. So this is where our argument and submissions go when we say that if you've got a tax charge at the beginning, you wouldn't expect it at the end, certainly not on the same elements which gave rise to the tax charge at the beginning. You would expect any further tax charge to sound in capital gains and to be taxed accordingly if appropriate. But this is, of course, why, if you make an election under section 431 to pay all the tax on the restrictions, on the restricted, on the unrestricted value, the gross value, if you like, at the beginning, and the shares subsequently go down in value, you've made a very bad bet. You get no tax relief for the income tax you paid previously. I handed up the British Venture Capital Association memorandum this morning, which I read out paragraph 6 of yesterday, which relates to ratchet shares, or shares with flowering rights. And it's clear from that that whether those rights are in the articles or not, the memorandum makes no distinction. And that's not surprising. It fits in with the frequently asked questions. So-called frequently asked for a very good reason, because these things come up all the time. And the Revenue put that title on the frequently asked questions in July 2003. The ink was barely dry on the legislation and they were being bombarded with questions. And the particular questions with which you're concerned today, they gave very clear answers to. Now, why was that? It was, in terms of market value having the same meaning throughout, for the reasons that I've just given you, Lordships. And as to why the first question I took you to, question K, which they repeated the answer to in the form of question M, so they made the critical answer twice in that place. The reason why personal rights are in is because this was meant to be a coherent code, and each and all of the provisions were not meant to be ones that the taxpayers could have a choice to opt in and out of by characterising provisions as personal, or putting them in a personal place so that they fell outside market value, or putting them in the articles or somewhere similar so that they came within. So when we come with that background to look at 3D and to consider what it's designed to achieve, our submission is that it has a very limited objective. It applies to stop loss and similar arrangements, incentive arrangements or incestuous arrangements with the employer of that sort. How is it limited? Because on the face of it, it seems to be very wide. Well, the answer lies in the provision we're talking about, in the market value definition or meaning itself. Because in this context, as in all the other chapters of Part 7 and as Chapter 1 directs us, it's got to have the same meaning. And then everything holds together. Then it all makes sense. It is coherent. Now, if personal rights are out, as the Crown contends, it's absolutely essential we know what their distinguishing characteristics are. But my learned friend, in response to, I think it was a question from my Lord Brown, to explain what a personal right was, responded that whether or not it was in the articles was not determinative, that there was no touchstone as to whether it affected market value or not. In fact, the only way to find out was to look at the particular chapter you were in, and it might be different in the circumstances of each particular chapter. So not only do we have an inconsistency in the different bits, but we just don't know. You've had no submission as to how do you know what you're looking at.
Well, the simple point might be, you ask whether it affects the value of the shares, whether it attaches, I should say, to the shares themselves.
Well, my lord, that was said, but how do you answer that question? I mean, here, there is no doubt that these rights had value, that they were all to do with Mr. Gibson's shares, that they came with an obligation to sell in circumstances where a majority interest changed in the company. So if they were acquired post 2003, they would be within the current restricted securities regime. He would pay tax on that basis under those provisions in respect of the restrictions. So if he sells at the point of sale, the restrictions haven't lifted, which would be the case because he's compelled to sell under the agreement when there's a change of control. So that's a disposal that's covered by the charging provisions within Chapter 2. And yet the Crown say he's within the charge under Chapter 3D as well. But don't worry, because we won't tax you twice, if that happens to be the way it works out. That's an astonishing proposition. It's not only astonishing sat on its own, but when taken together with what the Revenue have said publicly about what these provisions mean, it is completely astonishing. It's an extraordinary place we find ourselves in. And although the British Venture Capital Association memorandum is there, and I read the passage out to you yesterday, there's been no particular explanation from the Revenue as to whether or not the error or the misleading nature of the frequently asked questions bears on that as well. It is true that the frequently asked questions sat on the Revenue's website, and of course they were reproduced in professional publications. And it is true that they no longer sit on the website. But the Revenue have never said they've been withdrawn, that they're not to be relied upon. To this day, until my learned friend stood up before you and said they're not quite clear, they might be a bit misleading. So that's the first indication anybody has ever had. This is going to cause consternation down in the city, in the firms where lawyers deal with employee share schemes and the like. This is an extraordinary situation to be in. And it happens because my learned friend has sought to persuade your lordships that you just look at this little bit on its own and you don't give a coherent interpretation to the meaning of the market value in Part 7 in order to get home on the particular facts of this particular case. The other reason, my lords, why, apart from the reasons we've already been through, why market value throughout Part 7 may be talking about something which has to take into account personal issues, is that the context here is employment-related securities. And as my Lord Walker observed almost at the beginning of the hearing, that definition, which we looked at the beginning, that definition is of interest in securities, which feeds through to the definition of employment-related securities, is extremely wide in 420. All sorts of things are in it. Including interests in them as a separate category of security through the operation of 421B sub 8, or in a rather circuitous route which I took your lordships through yesterday morning. In this is the context we're in, so it's things to do with employment that affect value. Well, this is the context in which we are challenged to decide whether or not a technical distinction between something which is personal or not attached to a share is apt to be treated as affecting its market value. My Lord, with that preface to my further comments, what I would like to do now is just run through some of the things that my learned friend said and deal with them one by one in the order in which he said them. And some of them are fairly minor, but it will be expeditious if I simply run through them, I think. Please stop me if I'm going too fast. My learned friend referred to the principal cases, Crossman, Lionel, Fox and Clue, and said that the hypothetical sale takes place in the real world. It's important to note that in none of those cases was there a real sale. Lionel had some real world in it because the company was going to list the ordinary shares, but that didn't mean to say there were going to be actual sales. My learned friend said that the actual seller's rights under a collateral agreement, unless they are rights which are attached or embedded in the shares, they wouldn't affect the sum that a purchaser would pay. That is, of course, not consistent with the scheme, at least of chapters 2 and 3, specifically, where these things do affect market value and must therefore be taken into account in the hypothetical exercise that one has to carry out. A point I made yesterday, but my Lord, you said, so if something is assignable, it falls out. It doesn't come into the market value. If it's not assignable, it doesn't come into the market value. And my learned friend said, well, if it's personal, then it always falls out. So he didn't directly answer the question. Nevertheless, what I would submit in response to it at this point is that the forfeiture provisions in which Chapter 2 aims to deal with may be personal or maybe not. And when dealing with such provisions restricting or requiring an employee to give up his shares if he's a bad leaver or something of that nature, there is likely to be found in the employment contract or a collateral contract as the articles. In that, in Chapter 2, if you ignored those restrictions because they were purely personal, then the whole charging regime would misfire. They're clearly on board in Chapter 2. It is worth remembering that the whole argument in Crossman, which, my Lord, you asked a question about the right of restriction was a full right of restriction, then there'd be no value in the shares. But the right in Crossman reduced, the restriction in Crossman was a preemption right available to all the other shareholders. And it did, of course, affect the value because it was, as it happened, exercisable at a number that was below the external market value if it were possible to sell. So it was about price, albeit in the articles. Now, insofar as the actual rights were concerned with here are concerned, they were about price. And they weren't just about a price that Mr. Gibson could sell at. They were automatic provisions which compelled him to sell if there was a change of control. He couldn't stop it. So that sounds like something, although only applying to his shares, not unlike in nature the type of provision that was under consideration in Crossman. So this is where the difficulty of characterising, well, what's personal comes in. Is it because it had Mr. Gibson's name on it? Well, we've seen that there can be class rights which accrue to a named individual. Is it because it related to the price at which he would sell his shares? Well, we've seen in Crossman it can relate to the price at which shares have to be sold to other people. What is it that makes it personal? Is it because it's not in the articles? Well, maybe. But the Crown won't say. My Lord Roger asked the question, does the hypothetical seller have Mr. Gibson's rights? My learned friend said, well, it doesn't much matter because the question is what would the hypothetical purchaser be prepared to pay for? But of course, if in the hypothetical sale, the hypothetical seller has got these rights, surely the one thing the estate duty cases tell us is that we have to assume that the hypothetical purchaser could get hold of them, just as we assume in Crossman that he would be subject to the price agreement in the articles if he could get hold of the shares. It affects what he would pay, it doesn't determine what he would pay, but it's there. And Alexander is to a similar effect, although, as I accept, not bang on the money. As to Fox, my learned friend said the significance of that case lay in the understanding that the court was dealing with two items of property, a lease comprised in an interest in a partnership and the freehold reversion. And so it is very important, my lords, that apart from Lord Hoffman's general exegesis in the passage we were taken to, the rest of the case has to be treated with caution because it's a case about lotting in the context of of inheritance tax, where both items of property, the freehold reversion and the interest in the partnership, have to be valued. And the problem the court was addressing was the interaction between the two. Are they lottable? How does the one affect the value of the other? That's not the issue here. So that has to be treated with extreme caution, other than simply taking on board the general principles which Lord Hoffman very eloquently expounds. My learned friend made submissions about the fact that the shareholders' agreement had not been signed by everybody. And I think, my Lord Hope, you said, well, is it not significant that it's been passed by a 75% majority in the authorising resolution? We say that is significant when you bear in mind that the new articles were adopted in the same meeting. The new articles contemplate, on their first page, the issue of shares we're concerned with. And I think you'll find that at page 212 of the appendix. The paragraph which is numbered 5 on that page, but is in fact the 4th paragraph.
Yes.
Paragraphs numbered 4 and 5 should be 3 and 4, because if you turn the page, you then get 5 again.
Yes. And it refers to the...
It refers to the
14,465
shares.
Yes.
So this document, adopted at the same meeting, clearly contemplates the disapplication here of the pro rata allocation of allotments. And of course, the other significant thing in the subscription agreement, passed or at least authorised by a special resolution in this context of the relationship between the two is clause 11.2 at page 189 of the appendix. That's the provision which says this agreement, these provisions of this agreement shall prevail over the articles and any other articles. So the shareholders have gone to the trouble of passing a special resolution which authorises that at the same time as they've approved the new articles. So the point that was being made, well, look, there were some articles, why weren't the rights set out in that? There's a clear understanding of the drafting of these pieces of paper that they are interrelated, that the one affects the other. Now, whether or not as a matter of company law you accept that the logic of the propositions I was advancing yesterday evening and first thing this morning is one thing, but there is clearly an intention here to bind the two things together. And in the context of employment-related securities and market value, in that context, surely it is relevant that the authors of this document and the people who have approved it have done everything, bar sticking the provisions in the articles, they've done everything necessary to establish the rights here in a way which at least has equal authority and equal enforceability.
Yes.
My Lord, in relation to Cumbrian, my learned friend, Cumbrian newspapers case, my learned friend said that the rights that Mr. Gibson had fell into the second category. They were like the rights that a solicitor might have, and that was discussed is an old authority, I think, that my Lord Walker had in mind when he raised the question about that. We submit that they're very definitely not of that nature. They go to the price at which shares can be compulsorily required to be sold. They're exactly like, in nature, the rights considered in Crossman. The only distinction between Crossman in this case is that the rights are found outside the articles and they benefit only one person. Now, as to the latter point, Cumbrian establishes that if you're in the third category, that is, it benefits you as a shareholder, then it's okay if it's in the articles. So we're then left with only the one distinction. Does it matter if it's in the articles? Harman says, no, it doesn't. Admittedly, that was a unanimous shareholders' agreement in Harman. But what we've got here is this agreement approved by the company by special resolution in general meeting. Surely just as good, if not better, because the company itself is a legal party to it. So it was said that these were personal rights because they were not attached to the shares. They weren't enforceable against others. But for so long as Mr. Gibson owns the shares, he's under an obligation in respect of the shares to sell whenever the events that are set out in the agreement occur. He's got to sell his shares, so they are, at least to that extent, not personal. As to O'Neill and Phillips, my learned friend cautioned that this was a case really all about
There's minority rights, isn't it? And
all
infringement of
about
minority rights.
a quasi-partnership company.
Yes.
And I accept that that is indeed the substance matter of the case, and I would simply say that the point that we were relying on is that, again, Lord Hoffman, in reviewing the legislative framework, the background, at page, and this is in volume 3, tab 23, at page 1098, actually considers the two separate situations. So at letter G,
Page number again?
sorry, I beg your pardon, my lord, page 1098.
1098, yes.
These references are in the notes that I handed up this morning. The first thing to note at letter D is that His Lordship says that the concept is to free the court from the technical considerations of legal right. That's what unfair, the remedy in 459 in respect of unfairly prejudicial conduct is all about. And then if one goes down to letter G, in the case of section 459, the background has the following two features, emphasise two. First, a company is an association of persons for an economic purpose, usually entered into with legal advice and some degree of formality. The terms of the association are contained in the articles of association and sometimes in collateral agreements between the shareholders. And this was the passage which I took the Special Commissioner to. Thus, the manner in which the affairs of the company may be conducted is closely regulated by rules which the shareholders have agreed. And then secondly, he deals with the quasi-partnership point. And then picking up on the first feature again in the next paragraph at the foot of that page, the first sentence is the one that's run. The first of these two features, that's the agreements, etc., leads to the conclusion that a member of a company will not ordinarily be entitled to complain of unfairness unless there has been some breach of the terms on which he agreed that the affairs of the company should be conducted, namely those agreements which may be in collateral agreements about how it's to work. So, whilst that case did concern the second category of quasi-partnership arrangement, nevertheless, in his exegesis of the legal framework, Lord Hoffman makes it plain that shareholders' agreements are also susceptible to remedy there, so that, as I said this morning, if the subscription agreement does not form part of the articles, nevertheless, it does give rights enforceable under the Companies Act, if breached. It may do, and that would, of course, depend on the circumstances, because the remedy for 459 only arises if there's been unfairness in the sense that the courts have developed that term in that context. My Lord, my learned friend, having made the submission that the rights attaching to Mr. Gibson's shares were personal to him, then said, these shares are identical with all other shares. We are not to be assumed, or the purchaser isn't to be assumed to step into shoes in any strong sense. So as I understand the submission that was being made was because the rights are personal, then in the traditional market value exercise, this is something that will be left to one side. And that is clearly quite contrary to the sentiments expressed by Lord Roche in Crossman at page 74, which I took you to yesterday, where he deals with the specific issue of assets which are purely personal, are incapable of alienation. You have that in your notes, no doubt, from yesterday. But it is the answer to that point. The provisions in the sale agreement you were taken to, dealing with the receipt for the purchase money. And it was said, well, look there, the vendor's solicitors give the receipt, the purchaser doesn't care who gets what. But that's merely a question of the receipt. What the purchaser is interested in terms of the share sale agreement, and the relevant provision, my lord, is at 3.2.1. Of the sale agreement. So that's at page 237.
Yes. Yep, that's it.
But if I suggested to your lordship yesterday, the purchaser is interested to know that the rights under the subscription agreement have been dealt with and brought to an end, then what he's interested to know is that Mr. Gibson accepts that and can't deny it. And we say the combination of the consideration split in Schedule 1, taken together with the provision in 3.4, which says the vendors are entitled in those amounts, gives the purchaser that comfort that when taken together with this mechanism dealing with receipt, that the right people have got the right money, and certainly Mr. Gibson can't complain. 3.2.1 is not of great significance. It's just who can give a valid receipt. If it were the trustees of a bare trust, would it make a difference? Of course not. But instead it's the solicitors who are mandated to deal with the money in accordance with 3.4 of the agreement.
Yes.
My learned friend said, we're not looking at a genuinely open market which includes other shareholders who at some time might be prepared to pay a premium for Mr. Gibson's shares. I think I got that down right. But of course, the observation we have to take on board is that section 273 sub 3 of the TCGA directs us to go further than Lionel and to put in the hands of the prospective purchaser everything which he might reasonably require. In the present context, that's got to be, we would submit, obviously including the subscription agreement and the sale agreement. And that bears on Lord Hoffman's comments in Fox about the hypothetical purchaser reflecting the actual market, which, as Lionel observes, is actually a very narrow group of people, in fact. On 3D and the way it works, my learned friend's observations were, well, if it only applies to a stop loss, and he agrees that that's the paradigm case. If one receives a right to be bought out at a guaranteed price from one's employer, and that constitutes a separate asset from the employment-related security, that's something which would be like any other option which can be turned into money's worth and would be taxable under general principle when you get it. By contrast, if when the employer simply buys back shares which you acquired for X and you sell them back at X, it's not immediately clear that if X is above market value, that there is necessarily an emolument within the scope of the general charging provision. And the stop-loss provisions that this provision was aimed at, as I understand it, were sometimes quite complexly designed to ensure that it fell outside the general charge. Nevertheless, it is not the case that if our interpretation is correct, this provision will never bite. Because we say, if you get something in advance, you will be taxed on it anyway, on general principle, if it's got money's worth. And if at the time you sell pursuant to it, you sell to somebody like the employer rather than a third party who's willing to buy at a particular price, then clearly it will be in point. Although Chapter 3D doesn't say it, it clearly can't apply when the events in question are actually covered by the ordinary principal charge on employment income, because for the reason my learned friend said, the same occasion wouldn't be charged twice. But that principle can be taken too far, and one can't assume that the draftsman of these provisions drafted Chapter 2 on the basis that the revenue might have a choice between charging under Chapter 2 and Chapter 3D. And yet in Chapter 4 actually made a point of saying
Is it 449?
I think it is, my lord. I'm
Cases
sorry.
outside this chapter, so the
Yes.
opportunity was taken to make it clear that...
Thank you, I'm obliged. Sorry, my mind is dwelling on other things. It's odd that there's nothing comparable in Chapter 3D, but that's because it's much more closely integrated with Chapters 2, 3, and of course 3C. And my lord, it was suggested that the argument I put forward yesterday on the construction of Chapters 2 and 3 was essentially an argument based on redundancy. And I submit that that's not the case. The argument properly understood is that the draftsman, for example, when in Chapter 3 and 436, in B, he refers to a contract, agreement, arrangement, or condition. He's casting the web that wide because he perceives that within this context, all of these things are capable of affecting market value. It isn't just a question of casting the definition of convertible security widely. It operates both on the tax relief in the 437 and on the quantification of the charges under 440. These are things which are in the frame. So it's not purely a redundancy argument. The redundancy element of the argument is merely that if you ignore personal rights and restrictions for the purposes of chapters 2 and 3, then they misfire if the relevant provision is not encapsulated in the definition of the security or in its in the articles, for example, in relation to shares of a company. That's the redundancy element of the argument, but the centre of the argument is that as a matter of construing the provision, it's plain that the draftsman had in mind that all these wide things could affect market value. (423) subsection 1b, the market value of the employment-related securities is less than it would be but for that provision. What provision? These things which are contained in anywhere to do with freedom to dispose, forfeitures, etc., etc., etc. It doesn't matter where they are. And the same observations can be made about the provisions in chapter 3. There was a comment, I'm not sure whether your Lordship maybe picked this up, but in talking about chapter 2 and its purpose, my learned friend said it's all about restrictions and restrictions being lifted, but of course it's not, because it also catches disposals of securities which have a restriction still on them, or that which is unexpired. And we see that in the definition of chargeable events in 427 3C. And of course the same thing is true in relation to convertible securities. The events there are in 439 sub 3, and it is little b, the disposal for consideration of the employment-related security to somebody who is not a connected person. So disposals are in the frame here as well as in chapter 3D.
Yes.
And so when one's considering the purpose of both chapters 2 and chapter 3, yes, they are predominantly concerned with, on the one case, restrictions, on the other, conversion rights. But in both cases, they're not just concerned with the exercise or falling away of those features. They're also concerned with sales. So there is a real overlap with chapter 3D. And my learned friend's submissions accepted that there might be such an overlap, but he said that's fine because the revenue won't seek to tax twice in two different ways. Well, he says that, but that's no basis for the interpretation of a set of provisions which were enacted as a single code in one schedule to one enactment. To say, well, it's a bit incoherent, we can tax you under one provision or the other, and of course you'll have to guess which one we're going to choose, and the consequences might be radically different. Notwithstanding all this, the answer is to be found in the construction we've been advocating, to which the frequently asked questions, the Revenue's own view of the Act at the time was published, was set out. And that fits in with having market value as the one consistent principle throughout these provisions.
Well, I think you're at risk of repeating a point you've made many, many times now.
I appreciate that, my Lord. That was the comment I wrote down just before my learned friend started his third argument. On that point, so I think, my Lord, that concludes my response to my learned friend and the submissions he made, other than the alternative point, the new argument. And on that, he said we shouldn't put too much weight on what Lord Mackay said in paragraph 90. He wasn't considering the rights separately, and it wasn't raised before the court. But, my Lord, it was, of course, at the centre of the Crown's argument.
Well, we can read what Lord Mackay says for ourselves, and
indeed,
it's plain enough.
And you have my submissions on whether or not facts need to be found, and I think your lordships are on top of that. And so, my lord, I think, unless there is anything else that I can help you on, may I take a moment, my lord?
Could you just tell me something very basic indeed? In the 2003 to 4 year assessment, the top rate of income tax was 40%, was it?
I believe it was, my lord.
And
yes.
what was the rate of capital gains tax?
The rate of capital gains tax was 40%, but
Yeah.
40%. But two things you should note. Firstly, of course, the employer's national insurance would not be payable if this is capital gains tax rather than income, and that at the time would be 12.9%. I believe at the time the employee had a 1% charge to national insurance as well if it's income. But the critical difference, so far as Mr. Gibson is concerned, is that if the gain was a capital gain, although the headline rate was 40%, these were business assets, being shares in a trading company. And so he will be entitled to taper relief. And the effective rate of capital gains tax he was entitled to under that relief, and no argument he's entitled to it if it's a gain,
Yes.
is 10%. And if one considers the general policy of that, it's to encourage investment by entrepreneurs. Mr. Gibson put in a good chunk of money into this at the beginning. This wasn't a case of him simply being handed a share. He paid for what he got.
He paid for the shares.
He paid for what he got, my lord. Whether or not he paid more or less because of the shareholders' agreement is a question which goes back to his acquisition. But he certainly paid a lot of money at that stage for a very relatively small minority interest in a close company. And so that is, I would submit, a part of the framework of the answer
And
to the
there
question.
isn't any retirement relief involved here?
No retirement relief involved. The retirement relief was abolished when taper relief was introduced in 98. And then when taper relief went 2 years ago, there was a thing called entrepreneurs relief, which apart from not having an age restriction on it, was very heavily modelled on retirement relief. So these things come and go, my lord.
Thank you.
May I, my lord? My lord, unless there's anything else,
I don't think there is, Mr. Sherry. Thank you very much indeed.
I'm obliged, my lord. It has been an enlightening experience being in this place for the first time, and I just wanted to draw your lordship's attention to a curiosity of this case, which you may appreciate, you may have already appreciated. Of course, the taxpayer, as opposed to the appellant, is Mr. Gibson, and as the display in the basement here tells us, the architect of this building, the original architect of this building, was one James Gibson, a Scotsman. I thought you might appreciate that.
Well, we're extremely grateful to Council for the care they've taken in preparing their submissions for us in writing as well as the presentation orally in these last 2 days. We will take time to consider our decision.
Thank you, my lord.